Hi everyone, and thank you for joining us today for the second in our series of oil and gas CPD webinars for in-house lawyers. If you weren't able to join us yesterday, then don't worry, because we're actually going to be sending out recordings of all four sessions following our final webinar on Thursday. So for those of you who don't know me, my name is Laura, and I am a director in the oil and gas team here at Burness Paul. I'm going to be hosting today's session with my colleague David. David's also a director in our oil and gas team, and he's going to be handling our Q&A session later. So we have two topics that we're going to be covering today. First, we're going to hear from Jamie Kerr in our immigration law team, and he's going to be looking at the movement of workers between UK and European offices and offshore installations. And then our second presentation is from Stephen Guild and Jamie Wilson from our DR team. And they're going to be looking at some recent cases relating to climate activism and providing some guidance on contingency planning from a legal perspective. And then following both those presentations, we hope to have some time for a sort of short Q&A session. So please do send any questions that you may have in just via the chat function, just at any points throughout the sessions today. So first up, we've got Jamie. Jamie's a partner in our immigration law team who's worked in the field of immigration law for over a decade. Jamie has a broad client base, acting for individuals and businesses around the world. He deals with all aspects of UK visa law and policy, and he regularly appears in courts dealing with complex immigration issues. So over to you, Jamie.
Hi everyone, thanks for that, Laura. So today I'm going to be speaking about immigration and visa issues in very broad terms. I don't have long, so we're not going to go into a lot of detail on much of it, but essentially the point of the session today is to flag to you some of the items around movement of talent, around skills planning that really should be on your radar as we enter the midpoint of 2021. And obviously we're quite far down the line with Brexit. And from where I sit in terms of dealing with free movement of people, my view is that the impact of Brexit has yet to be felt by businesses, and I suspect so many businesses are not yet prepared for what is going to come as we move out of the pandemic and get back to international travel and cross-border activity picking up again. So I suppose the starting point for that discussion on migration, on visas and on visa strategy, people strategy, movement of people, is that things have changed, and things have changed pretty fundamentally. Brexit happened quite some time ago. I don't think anyone can remember when it happened, because we didn't notice Brexit actually happening when Britain or the UK left the EU, and that's because it was a transition period, and the transition period essentially almost everything stayed the same when it came to free movement of people right up until the 31st of December 2020. So we would have seen a more dramatic impact of Brexit at that point, but for the impact of COVID and the pandemic, the lack of travel has meant that we, both business travellers and tourists, have yet to see the challenges that we're going to face with travel for business and pleasure to continental Europe. So I suspect because we've not felt that hard impact of the Brexit process, we've not quite realised, or many people haven't realised, that EU free movement of people is finished. So the concept that you can send an engineer or a member of staff on a plane to a job in Paris or Germany or Bucharest or Tallinn or Helsinki or whatever, to do any job they wish for any period of time they wish, that's not happening anymore. And likewise, it's not possible for Europeans to simply come on a plane to work in the UK. So Europeans, essentially, when it comes to UK migration, are now treated in the same way as non-Europeans when it comes to visas in terms of working in the UK and living in the UK. And I think that's something that you need to recognise, and secondly, you need to be prepared for, because of the challenges in both directions. In terms of Europeans who were already here before the end of the transition period, they are all covered by the EU settlement scheme. So the rules are generally that as a result of Brexit, free movement of people has ended, but Europeans who were already living in the UK before the 31st of December can register under the settlement scheme to protect their ability to continue living and working in the UK. Those arriving after that date are subject to the new immigration rules. The only real exception to that is Irish nationals who essentially retain free movement in the UK for historical reasons that go back to the 1920s. So Irish nationals can still come and go from the rest of the United Kingdom, but Europeans who aren't eligible for the settlement scheme cannot. So what that means is that you should be thinking about ensuring that your existing employees who are European nationals are already registered under the settlement scheme, and that's open until the summertime, 30th of June, that ends. For Europeans who are coming to the UK after the 31st of December, so from the 1st of January this year, who are not eligible for registration under the settlement scheme, you will require to either sponsor them or they'll require to meet the visitor rules. There is another category which I think is probably underused at the moment, but is probably of real interest to the sector, and that's the frontier worker permit. So that's for people who didn't live in the UK before the 31st of December, but who worked here. So the classic example would be someone who lives in continental Europe and travels to Aberdeen, for instance, for work purposes, whilst continuing to reside abroad. There's a new frontier worker permit that they are allowed to use or apply for, that they're able to apply for. Again, that I think that's due to close in the summer, that scheme as well. So there's a very short window for people to register under that scheme. But I think that could be of interest in terms of trying to squeeze contractors and the like who you deal with into that frontier worker scheme. It's not quite clear at the moment what the Home Office approach is to that scheme, and how generous they are being, because the processing is rather slow on it. But if you have people living in continental Europe who work for you here or offshore, then you should be looking at that scheme if they can qualify under the settlement scheme. The more challenging area, I think, is going to be, or challenging areas are going to be around visitors. Because under free movement, when it comes to Europeans, we were used to them just coming into the UK and staying as long or as short as they wish. And the same with British nationals going to continental Europe. But many of you will know, in terms of the rules around non-Europeans, there's a degree of complexity there. Certainly there's a degree of complexity around the offshore rules. And there's all sorts of variants for the offshore rules depending on where they're going, if they're seafarers, if they're going on to installations that are not bolted onto the seabed, etc. So that complexity that there is around non-Europeans is now there for Europeans as well. And I think that's going to be quite a dramatic impact, especially when you get into issues of people coming in and simply transiting offshore again. So you have to understand now that the rules that were traditionally there for non-Europeans are now there for Europeans as well. And I'm not convinced that the Europeans themselves are aware of that. So I suppose you as employers are going to have to get a better grip on what your staff are doing when they're coming into the UK, and making sure that they're not doing anything that the visitor rules would prevent them from doing. So the obvious example would be someone working between an offshore installation and the office in Aberdeen, So Europeans would have been able to do that, but we know that that's more complicated for other nationalities, Indians, Filipinos, Americans, Israelis, the like. In terms of the visitor rules, all Europeans at the moment are treated in the same way that, say, Americans are, Australians, Israelis, Brazilians, to the extent that they don't need to apply for a visa before they travel. And the contrast to that is countries like most of the African countries, India, Nigeria, Russia, or Ukraine, where their nationals would have to apply for a visitor visa before they come. So Europeans are not in that category. So that makes it easier in a way that they can just come over, speak to an immigration officer at the airport, tell why they're here, and then be permitted entry. But that also brings its challenges, because it means that visitors are able to operate under the radar, as it were. So if you have someone coming from a country where traditionally they would require a visa before they even come as a visitor, then there's someone in your organisation having to issue letters of invitation and paperwork and that type of thing. That's not the case with those who can enter without a visa in advance. So it means that your policies have to be robust, and your management teams or your recruiting teams have to be alert to what the visitor rules are, what people can and cannot do, how long they can stay for. So visitors is going to be a real change to the way that we're used to operating with European nationals. The other challenge on visitor rules is that there's a new criminality. There's new rules on criminality, which before, in relation to those entering the UK with convictions, there were rules which were discretionary grounds of refusal. Now they've been made mandatory. So for certain convictions, or for those with certain convictions, the UK just becomes a no-go zone. And that's going to have quite a dramatic impact on some Europeans who have been convicted of offences for which they've had a custodial sentence, a prison sentence of more than 12 months, or those who have got more than one offence, persistent offenders. So we're going to see challenges in relation to criminality. So if you have people that you're aware, if you have staff who are European who travel to the UK and you're aware that they have convictions, and again, you should be seeking some guidance on that, because that's going to be a dramatic change. The other area which is going to be a really significant change on the visitor rules is outbound work. So my team have tended to focus on inbound immigration work to the UK. With Brexit, we've been looking more at outbound work to Europe, because Britain is now outside of the European Union and the European Economic Area. The transition's ended, so we're treated in the same way that other third country nationals are treated when we go to Europe. And that means that we're now caught by things like the Schengen zone rules, and American companies, Chinese companies, Indian companies are just used to dealing with Schengen zone rules. We are not. And the general rule of thumb for going to the Schengen zone is that you're only allowed to spend 90 days in any 180-day period there. And that covers business travel as well as personal travel. So that's going to be a challenge if you're regularly sending people to Europe, because you'll need to keep track of the number of days that they are inside the Schengen zone. And I think, to add to the complexity, the Schengen zone doesn't cover all of the EU nations. I think there are some countries that are not in the Schengen zone. Romania and Bulgaria are not, and I don't think Cyprus is, and Ireland's not. So there's a level of complexity in terms of trying to figure out who has been where, and it might be easy enough for you to keep on top of your employees' business travel to the Schengen zone, but when you get into trying to account for their personal travel, if they've been a romantic weekend to Paris or a stag weekend to Ibiza or somewhere like that, those periods could have a knock-on impact on your ability to send them to jobs in the Schengen zone. And the other challenge is that the rules as to what is permitted under the visitor rules still vary slightly from country to country. in Europe. So what is permitted in Norway under their visitor rules is going to be slightly different from what's permitted in Finland, which again will be different from what's permitted in Italy. So there is real complexity being brought into the movement of people between Europe and the UK in both directions. I think the inbound side you should probably be able to deal with. We can do everything on the inbound side. The outbound side is probably more of a challenge in terms of changing your systems quite dramatically. If you're part of a bigger group, then it might be easier for you because the US entities will be grappling with these rules anyway for Europe, but it's going to be a real culture change in my view for us in the UK. Just very briefly before I finish off, on the new immigration system, there is a new immigration system which now covers Europeans. It looks very much like the old visa system that covered non-Europeans. So essentially, all the government has done is extend the visa system that covered non-Europeans over to cover Europeans as well. So there's not that much new in the system. The good thing is that they've simplified some aspects of the system to make it easier. And if you deal already with recruiting non-Europeans, then the system that we have now is much simpler, to the extent that the requirements to advertise, the requirements to advertise jobs in the job centre, the requirement to wait once a month to get certificates to sponsor people, that's all gone. In my view, it'll likely all come back in about 2 years' time. But for the moment, it's all gone, and the system's more streamlined, quicker, and better to use. If you're on the call and you don't already deal with non-Europeans and you don't have a sponsor license, or you don't have sponsor licenses to sponsor non-Europeans, then you should really start thinking about obtaining a sponsor license, because you'll likely need it for recruiting Europeans who are not already in the UK. So that's, if you're not already dealing with the immigration system, it's worth looking into it now. So we're quite busy at the moment advising businesses or helping businesses obtain sponsor licenses. It's not a bad process. It's not overtly complicated, but it's time consuming. It takes a lot of time. It doesn't move quickly. So you really need to be organised in advance if you think you're going to be recruiting European nationals. Some other stuff has changed in terms of the terminology of the Tier 2 licenses, which for those with existing licenses, you probably need to update your handbooks on, or your processes on, make sure your level 1 users know what the changes are. There's been some really good changes, which I think will help your sector around cooling off periods. So traditionally, when you brought someone in, or you transferred someone between linked entities outside the UK and in the UK, you were hit with cooling off periods where they had a 12-month entry ban, as it were. They couldn't come back in until they served their cooling off period. Those are away. So that's a really significant change that will make things easier. The intra-company transfer license, which is used in your sector a lot, is currently being reviewed by the Migration Advisory Committee. There's a consultation out looking at that. So if any of you use that license a lot, then you should either feed in directly to the Migration Advisory Committee as to what works and what doesn't work for you. The key benefit of that license for your sector is the exemptions from English language requirements, so you probably would not want to see those go. If anyone's got any views on intra-company transfer sponsor licenses, then just drop me an email or contact me through your contact at the firm, and we can feed it in for you through other channels as well to make sure that your feedback's getting back to the Home Office. That's probably all I wanted to update you on. We have a very short slot, and probably each thing I mention is possibly a session, or is a session in itself. But just to recap, what should be on your radar is existing staff, making sure that they are registered under the EU settlement scheme before the summertime. Secondly, making sure that you have your sponsor licenses either in place or up to date to enable you to sponsor new employees in. Thirdly, looking at existing staff, existing contractors, to see if you can squeeze any of them through the frontier worker route to allow them to come and go, not spending more than half the year here, because that's a really good concession that's potentially lost. Fourthly, looking at the outbound rules for sending people to mainland Europe for short periods of time, making sure that you're on top of that, that you have some sort of system for counting people's time spent in the zone, and that you have a strategy for dealing with outbound stuff. I think that's probably the hardest aspect. And finally, fifth, just being alert to the changes to the current visa system, being alert to the reduction in skill level for jobs, so you might be open to a wider pool of jobs, and knowing what's happening more broadly, which we can help keep you up to date on. Primarily at the moment, the key thing being changes forthcoming to the intra-company transfer route, and also some changes happening in 2 or 3 weeks' time to right to work checks. That the concession that was in place for the coronavirus, whereby you could do checks on Teams or Zoom, is disappearing again, and it means that right to work checks have to be done face to face again. And I think the date is the 17th of May is the date that those changes come into effect, which is obviously well in advance of the date that the government guidance gives for offices reopening. So the Home Office expect someone to be in your office to conduct right to work checks in advance of the rest of the government expecting people to be in the office. So we just put out a notification on that. So if you're not already on the mailing list, getting those notifications about updates like that, then again, contact your contact in the team. So that's probably all I have to say at the moment. I'm happy to take questions at the Q&A later on. Hopefully there's something in there of use, and we're always happy to pick up on anything migration, visa related, personal migration, business migration, and corporate migration. So anything at all, just ping us an email.
Perfect. Thank you very much, Jamie. Some really good information there on movement of workers between the UK and the EU. So yeah, as Jamie mentioned, we're obviously going to be having our short Q&A session at the end. So please just keep your questions coming in via the chat function for our speakers. Right, so we're now going to hear from Stephen Guild and Jamie Wilson in our DR team. So Stephen is a partner, and he's also a solicitor advocate, and he regularly acts on a wide variety of disputes, including complex contractual disputes, insolvency and property litigation. And Stephen is joined today by Jamie. Jamie is qualified in both Scots and English law, and he has significant experience advising and representing clients on a range of disputes, including a lot of contract disputes in the oil and gas sector. So over to you, Jamie and Stephen.
Thanks, Laura. So Jamie and I are going to be looking at the issue of climate activism today. In other words, environmental protests. This is obviously a topical subject, not only for the energy sector, but society as a whole. It's also topical from a disputes point of view, because there have been some recent cases, and Jamie and I have been assisting some of our clients plan for possible protest at their sites. Our presentation today will be in 2 parts. First, I will briefly look at some of the key recent cases and highlight some points arising from them. Jamie will then look at the planning that can be done in advance of a protest taking place, bearing in mind the points arising from the cases. Although Jamie touches briefly, or will touch briefly, upon health and safety issues in his talk, including training your own staff to deal with protesters at your sites, vessels or installations, we simply don't have time today to look in detail at health and safety planning. Our focus instead is on planning for court action, nor do we have time to look at the issue of contractual liabilities, indemnity, force majeure, etc., that might arise up and down the supply chain if financial loss is caused by a protest. But if you'd like any information on these matters, do feel free to contact us after the seminar. Before I look at the cases, just a couple of introductory remarks. First, traditionally protester cases have involved operators or producers rather than contractors. So Shell, BP, Cairn Energy in offshore oil and gas, as well as INEOS and Quadrilla in the context of onshore fracking. That said, the most recent Scottish case of any note involved a drilling contractor, namely Transocean, and the evidence would suggest that the protesters are now far more prepared to target and disrupt the supply chain. Second, whether it's Bernard Looney, CEO of BP, or President Joe Biden, it seems beyond doubt that there must be a transition to net zero and beyond, and perhaps the only debate is how quickly that should happen. As the protester cases involve the balancing of rights, on the one hand, the right to freedom of expression, and on the other, the right to carry out lawful business activities, we may see the courts affording greater leniency to protester activities as time goes on because of the perceived importance of the moral issues at stake. And there's already evidence of such leniency in the Dutch courts, although thus far not in the UK courts, at least as far as civil judges are concerned. However, on Friday of last week, 6 Extinction Rebellion protesters were acquitted by a jury of causing criminal damage to Shell's headquarters in London on 15th April 2019, despite admitting to breaking windows and spraying graffiti, and in spite of the judge directing the jury that there was no defence in law to the charges, however morally right the protesters might believe their cause to have been. The jury acquitted the protesters anyway. And just for the avoidance of doubt, that was a criminal prosecution before a jury. Our focus today is principally concerned with the civil courts, although to confuse matters slightly, a deliberate breach of a civil court order can result in criminal penalties such as fine or imprisonment. So with those introductory points having been made, let's have a look at some of the cases. There are many civil cases relating to protests in the last 10 years or so, but for today's purposes, I'll highlight 5 as they involve energy companies. In Scotland, the main cases are concerned with offshore oil and gas activities, but by contrast, in England, the 2 most recent leading cases have centred on fracking at onshore locations. Although different on the facts, they do raise similar issues. So dealing with the Scottish cases, of which there are 3, and working back in time. The first is Transocean against Greenpeace from 2019 and 2020. It concerns a mobile offshore drilling unit operated by Transocean, which was contracted to BP. It was boarded by Greenpeace protesters on 9th June 2019 as it sought to leave the Cromarty Firth on its way to the Vorlich field. The next day, the Court of Session, Scotland's High Court, granted an interdict, and the English law term is an injunction, preventing Greenpeace and those who were on the legs of the unit occupying the rig or entering within 500 metres of it. Greenpeace protesters willfully breached the order twice in the next few days, first by boarding the rig again, and second by attempting to do so, this time while the rig was nearing the field. Transocean then brought contempt proceedings, and Greenpeace were eventually fined £80,000, ordered to pay Transocean's legal expenses, and one of their executive directors was almost jailed as he was found to be, quote, culpable to a very high degree, having orchestrated the incidents in willful defiance of the court order. Some of the activists were also prosecuted separately in the criminal courts and given community service orders. The second case is Shell against Greenpeace from 2019. Here, Greenpeace protesters boarded Shell installations in the Brent field, which were in the course of being decommissioned, but not fast enough and in the right manner for Greenpeace. Again, the Court of Session granted interdict to effectively end that protest. Breach of the order was not an issue in this case because Greenpeace withdrew after service of the interdict. Some of the protesters were also prosecuted in the criminal courts for breach of peace. The third Scottish case is Cairn Energy against Greenpeace and persons unknown. Although the case concerned Cairn's drilling activities in the Arctic, this case involved a protest and indeed significant disruption at Cairn Energy's offices in Edinburgh by Greenpeace protesters. Their protesters dressed in polar bear suits ran amok, taking away confidential information in the process. And again, an urgent application was made to court, and the court granted interim interdict against Greenpeace, which had the effect of stopping the protest. In England, as I indicated earlier, The two leading recent cases concern fracking. The first is Quadrilla against Lorry and Persons Unknown. This is an English court case, indeed a High Court case concerning Quadrilla's fracking activities near Blackpool in the mid to late noughties prior to the government moratorium on fracking. Here there was no organised group like Greenpeace, just a disparate group of protesters calling themselves Reclaim the Power. In 2016, part of the site had been occupied by the protesters, and at that time, Quadrilla obtained a court order to remove them and also an injunction preventing future occupation. However, for a period of 18 months from January 2017, there were further incidents during which works were disrupted. For example, protesters chaining themselves to objects or to each other at the site entrance to prevent access being taken by contractor lorries, slow walking on or blocking the public highway and access road leading to the site, climbing onto and chaining themselves to lorries, intimidating Quadrilla staff and contractors, and so on. This caused not only substantial disruption to Quadrilla, but also to local residents. Over the course of the 18-month period, there were apparently 350 arrests, and the policing bill was estimated at £7 million. As further protests were planned, the court issued a further injunction in June 2018 designed to deal with all of the disruptive activities, not just trespass or unlawful occupation. A number of protesters ignored that order, willfully breached it, which led to the court finding them in contempt. One protester was sentenced to close to 3 months in prison, which was later reduced slightly on appeal, with another two receiving suspended sentences. And the second and final English case is Ineos against Persons Unknown, which took place over the course of 2017 to 2019, concerning Ineos's fracking activities at various sites in Yorkshire. Ineos obtained injunctions in the English High Court, principally against Persons Unknown, but there were other named persons on similar terms to those obtained by Quadrilla and in relation to similarly disruptive activities. So those are, or that is just a brief summary of some of the recent case law. What I want to do with the rest of my time today is just highlight 10 points arising from the cases, which might be worth bearing in mind. Point one is that the energy companies usually get the order they ask for, and in that sense might be seen to be the winners. There's perhaps an obvious reason for such success, which is that the modus operandi of the protest groups is civil disobedience. Their thinking appears to be that unless their protesters actually disrupt operations or damage property, their message is unlikely to be heard, let alone cause any industry or societal change. Protesters can stand with placards in a city centre peacefully protesting, but they presumably figure that unless they actually block a highway, sit on top of a vehicle, or get onto a rig, the public and media probably won't pay much attention. And as we saw last week, Extinction Rebellion smashed windows at the offices of Barclays, HSBC and Lloyds Group to protest about those banks' investments in oil and gas. If windows had not been smashed, would those incidents have generated any publicity? Probably not, and that's point one. Point two is that the disruption to the energy company's operations and its supply chain more generally often results in significant financial loss. And so to that extent, there are perhaps no winners here. The reality is that most individual protesters do not have assets to meet claims for compensation. And as for organisations like Greenpeace, they are in a position to pay significant compensation, but such claims are almost never pursued, presumably because drawing Greenpeace into a long court battle about financial loss is unlikely to create good PR for the energy company, can create martyrs out of individual protesters, and it can be difficult to prove loss with precision. Where there has been financial consequences for Greenpeace, as in the Transocean case in which Greenpeace was fined £80,000, Transocean did not see a penny of that because it was a fine payable to the public purse for contempt of court. Now, £80,000 is perhaps not a small sum, but on the other hand, the case report suggested that Greenpeace is able to raise in excess of 20 million a year to fund its operations. So perhaps just a drop in the ocean. Point three is that past case law and success for energy companies does not seem to deter future protester activity. At best, it just stops the protest in hand. It's open to debate why that would be the case. Clearly, these protest groups exist for a specified purpose and are unlikely to give up the fight. But historically, civil courts are reluctant to impose harsh punishments for breach of interdict, which may limit the deterrent effect. Of course, there can be separate criminal prosecutions and punishments, but you're relying on the police and prosecuting authorities to act. In the Transocean case, it did look like one of the executive directors of Greenpeace was close to receiving a prison sentence, although even then it was likely to have been suspended, perhaps until a court hands down a significant custodial sentence to a protest group director. It's questionable whether contempt proceedings will have any deterrent effect at all. And as it stands at the moment, frankly, based on the case law we've seen, a custodial sentence seems a remote possibility, at least for a director of one of these protest groups. Then again, if it wasn't already obvious, both the Shell and Transocean case reports seem to confirm that the courts are aware of how dangerous it is for Greenpeace protesters to be on or in the vicinity of drilling rigs in the North Sea. Perhaps it will take the death of a protester, a vessel crew member, or indeed a police officer before the court will see fit to imprison a protest group director. Point 4 is that notwithstanding success to date, the case report suggests that it's becoming harder for energy companies to obtain interdict or injunction. The written judgments in these cases get longer and longer. For example, the Transocean case report is 59 pages long, principally because the protesters are prepared to run arguments that they might not have run in the past, including on human rights grounds. That's point 4. Point 5 is that these cases certainly engage human rights issues. That's beyond doubt. And to that end, the protest groups usually make the argument that they are not acting unlawfully, even if causing disruption to commercial activities, because they're exercising fundamental rights of expression and assembly under Articles 10 and 11 of the European Convention on Human Rights, which effectively forms part of UK law by virtue of the Human Rights Act, and which is unaffected by Brexit, at least for just now. There is no doubt the rights to expression and assembly are engaged in the context of environmental protests, but they are not unqualified. The courts have repeatedly said that they must be exercised in a proportionate manner, balanced against other rights, including the right of persons, including companies, to carry out their lawful commercial activities. And certainly once a court has granted an order, human rights are unlikely to have much influence on the court. And where deliberate breach of an interdict has put public servants at risk, in the Transocean case, the police and the Coast Guard, this can be seen as an aggravating factor by a court. Point 6 is that, at least up until now, the courts have held that there are clear limits to the exercise of rights of expression and assembly. And in that sense, a clear distinction has been drawn by the courts between conduct which causes disruption as a side effect of the protest, and conduct or protest which is deliberately intended to cause disruption to a party carrying out its lawful commercial activities. So chaining yourself to an offshore drilling rig at sea or invading private offices will almost certainly fall on the wrong side of the line. That said, and this is point 7, the courts are expected to take a cautious approach about granting an interdict to prevent a protest in advance of its starting. In both the Shell and Transocean cases, interdict was sought only after the protest had begun, with Greenpeace having boarded the Brent installations and the Transocean rig respectively, and thus the interdicts were designed to prevent future occurrences of disruptive behaviour. The court therefore had a clear idea of what had happened already at the sites and was likely to happen in the future, and thus had the evidence before it at the interim interdict stage to carry out a proper balancing of rights. Where a protest has merely been threatened but has not yet begun, it will be harder to persuade a court to grant an interdict, because the court will be concerned it might be acting disproportionately, since until it's actually heard any evidence about the protest and who indeed is there, it will not be able to say for sure that it is unlawful. That's point 7. Point 8, to illustrate that point, the outcome of an application for interdict cannot always be predicted with certainty, even where there is evidence in advance there's likely to be significant disruption. For example, there's a 2012 Dutch case involving Shell relating to expected protests by Greenpeace at a number of Shell petrol stations in the Netherlands against Shell's drilling activities in the Arctic. The fear was that the protesters would interfere with customers buying petrol on the forecourts, cause criminal damage, and cause a nuisance on the hard shoulder next to the petrol stations. But the Dutch court declined to grant injunction in advance of the protests taking place. It went on to suggest that in most cases, Shell's remedy will be to sue the protesters or involve the police, but only after some legal wrong has been committed, rather than to obtain an injunction in advance. Only if, quote, substantial damage is likely to occur did the court say we get into the territory where a court should think about granting injunction. However, the Scottish judge in the Scottish case involving Shell, namely Lady Carmichael, declined to follow the Dutch court, holding that it had not applied the European Convention correctly. And as far as I can see, the position in England is identical to the position in Scotland. But nevertheless, the direction of travel may be one way. Point 9 is that many recent protests involve a different breed of protester group than those that have historically carried out protests, which potentially has implications for the effectiveness of the orders obtained. So at one extreme, you have Greenpeace, which is a well-organized, well-resourced organization with a corporate structure, which directs protests in its name. Notwithstanding that in the Transocean case, Greenpeace initially denied any responsibility, claiming that the protesters were acting alone and at their own risk, the court will usually be prepared to hold that Greenpeace are in control and are the correct party to sue. Thus, interdict Greenpeace and you can usually put an end to an incident. The jury, however, is out with respect to organisations like Extinction Rebellion, who arguably lack the corporate structure and centralised management of organisations like Greenpeace. There's accordingly an increasing risk that you might obtain an interdict against one disparate group of protesters only for another arguably unrelated group to pop up in its place with the need to take further expensive court action. That said, in England, in both the INEOS and Quadrilla cases, the courts have been prepared to act flexibly with respect to the terms of the injunctions they grant, although the point is untested in Scotland. And finally, just a quick word about punishment, particularly for directors of environmental organisations. In order to be punished for contempt of court, there must be a willful breach of a court order, in this case an interdict. As regards an actual living person, that involves proving to the criminal standard, that's to say beyond reasonable doubt, that there has been intentional wrongdoing. As for a company, it has a duty to take all reasonable steps to ensure that its staff, agents and contractors are aware of the terms of the interdict once granted, and if it fails in that duty and its staff, agent or contractors breach an order, the company is in contempt and liable to be fined. But as alluded to earlier, it is also in particular circumstances competent to imprison a director of a company, although the sentence is usually suspended. In order to get into that territory, the court will be looking for an individual within a protest group of sufficient seniority, amounting in effect to the controlling mind of the protest group, and whose conduct renders him or her responsible for the company's breaches of the order. In the Transocean case, one of the executive directors of Greenpeace met this test because he authorised the action from the start and was in every sense the will of Greenpeace in support of the action. The court said he could have brought it to an end at any time, and notwithstanding his knowledge of the interdict, he did not call off the action until after the order had been breached on 2 occasions. However, as I've said, in the end, he did not receive a custodial sentence, not even a suspended one. So that's point 10. That's all I propose to say about the cases today. But frankly, we could probably spend about an hour or so in each case. But I'm now going to hand over to Jamie to talk about some of the planning issues that you need to think about in order to properly prepare your application for interdict or injunction. Jamie.
Thanks, Steve. So how do you plan for a possible protest taking place at your site? Well, I have 12 points to make in this regard today. First of all, as can be seen from the case examples that Steve has just gone through, protests can take place in many different shapes and sizes. There have been protests both onshore and offshore at office blocks, oil rigs, gas facilities and workshops, just to name a few. Some of these protests have been large-scale operations involving organised groups of hundreds of people, such as Greenpeace, whereas others have been much more smaller-scale operations involving only a few individuals. The devil is in the detail. So as a minimum, you need to know the facts of the protest so you can tell the court. In our experience, many onshore installations or terminals have complicated titles, and it can be difficult to work out where precisely site boundaries lie from title deeds, where a private access road begins, where the land becomes public, whether parts of a site are tenanted or licensed to other operators, and so on. So you need to pull your title deeds out to clarify the position, and that process itself can take some time. The court will want to know because firstly, you need to establish that you have title to sue, and secondly, a protest on public land might be treated differently from a protest on private land. While protests on public land are less likely to be interdicted because of rights of freedom of expression, it is still possible for a court to interdict a protest group from protesting on public land if they are doing so in a way that is designed to materially disturb or impede the lawful operations of, say, an energy company. However, on the other hand, a court is entitled in theory to also permit a protest on private property, even if that protest is causing disruption on that land. The devil will ultimately be in the detail. Secondly, this public-private land distinction can be important, as it will allow you to understand the extent to which any criminal wrongs are being committed, and whether the police are likely to intervene if they are called. For example, blocking the highway is a criminal offence. Protesters could be charged with breach of the peace, which is also a criminal offence, and damage to property can engage criminal law, and so on. Trespass in Scotland is a slightly more complicated matter. In its pure form, it's temporary intrusion onto another's land without consent, and that is generally a civil wrong rather than a criminal one. Although the right to roam legislation does also grant public rights of way, which complicates matters further. That said, permanently occupying a land without consent can be a criminal offence, under the Trespass Act of 1865. The third point is whereas once the court might have been prepared to intervene simply because there was evidence of disruption or likely disruption on private property, the cases do confirm that this is no longer the case. As cases involving protesters are likely to generate publicity, and with the judge being named in the press, many judges will take a more cautious approach. It is therefore important that the QC or the senior advocate that you instruct has the confidence of the court. Sadly, as solicitors, we have all been involved in cases which have not gone to plan because the wrong advocate has been chosen. In Scotland, there are only a limited number of QCs who command the confidence of the court, and even fewer of those QCs have experience in this type of case. It is therefore important you get the right one. Hence, there's often something to be said for retaining and briefing the right QC well in advance to ensure you are as prepared as possible. Fourthly, as protests tend to be mobilised in a short period of time, and as disruption can escalate very quickly, it is advisable to get your court action before a judge as soon as you possibly can. As Steve explained earlier, if you go in too early, you run the risk of jumping the gun, with the court holding that there's not enough evidence to justify the court order that you seek. However, you can usually tell as soon as protesters are on site what is going to happen and be able to advise the court accordingly. Time is ultimately of the essence. You do not want to get bogged down trying to find title deeds or drafting court papers and the like. If you prepare properly in advance, there's no reason why a court could not hear your application for interdict on the same day or the day after the protest has begun. The fifth point is that what is happening on the ground will inform which court remedy you should choose to seek. Scots law is a remedy-based system. While this is good in theory, in practice the law can be a little inflexible, in that it becomes important to choose the right remedy to fit the facts of your case. There are two possible court orders that you could seek in order to try and thwart a protest. These are firstly an interdict, or an injunction in England, to preclude the protesters from taking unlawful action at your site, or instead an order under Section 46 of the Court of Session Act of 1988 for protesters to be removed from your site. If you choose the wrong remedy, you could run into problems. Accordingly, establishing what is happening on the ground can be critical to choosing the right remedy. Whether you get an interdict or an order for removal, the order will be served by sheriff officers. In the case of removal, sheriff officers are actually empowered to physically remove the protesters if they do not leave voluntarily. And as Steve mentioned earlier, in some cases, you could seek both remedies, first an order for removal, and then an interdict to stop the protesters from returning. The sixth point is that you can obtain an interdict without the protesters knowing about it until you actually serve the court order on them. Whether the protesters are first given an opportunity to oppose that order depends on whether they have lodged what is known as a caveat with the court. If they have not, then they do not get any prior notice. But in those circumstances, there is a heavy onus on an applicant's legal team and their QC to present as full, fair, and accurate account of the facts as possible. There can also be consequences if that is not done, both in terms of professional conduct and damages for wrongful action. It thus follows that your legal team needs to know the facts. If you go into court less than fully prepared and get a judge on a bad day, the order may not be granted, and that can send the wrong tone right at the outset. The seventh point is that although a court might be prepared to grant an order for removal against unknown persons where there is actual unlawful occupation of a site, there are question marks in Scotland about whether an interdict can competently be granted against unknown persons where their behaviour is purely disruptive rather than based on occupation. However, even if such an order might be competent, it's best to still name the protesters if you can in the court application, because if you do not, then it can be difficult to prove that specific protesters have been given notice of a court order by a particular a court order, and in turn to prove later on that there's been willful defiance of a court order by a particular protester as part of contempt proceedings. In such circumstances, the court may decline to punish them, which in turn may simply encourage future protests. In our experience, there can be information in the public domain or on social media which identifies specific protesters or groups, but it can often be prudent to also instruct sheriff officers to attend the site to do a report. For example, we regularly instruct sheriff officers to attend individual sites occupied by traveller communities, and sometimes these reports will help to identify particular persons. At the very least, the report will usually provide an independent record of what's happening on the ground, which can be of assistance to the judge who is ultimately hearing the case. The 8th point is that as the court has a discretion about whether to grant an order, the more that can be done to demonstrate the health and safety risks or some other aggravating factor beyond mere intrusion onto private land, the better chance you have of obtaining the order. Bear in mind that even if the protesters claim to be protesting at their own risk, an energy company occupying land still owes duties of care, even to trespassers. Accordingly, not only can health and safety risks to a company's staff and contractors be relevant factors for a court, but also risks to the protesters are also relevant. Again, if time permits, a report from an independent health and safety expert, or indeed from the company's health and safety team, can be an important piece of evidence for the judge. Of course, sometimes the risks are so obvious that a health and safety report is not required, but sometimes the position is more nuanced. The 9th point is that the benefit of a proper health and safety risk assessment, aside from its use at court, is that it will allow you to plan your site activities when the protest is ongoing. In other words, it will allow you to demonstrate whether you can reasonably continue operations and in what respect while the protest is ongoing. Clearly, a loss of a day's production or a site shutdown could be very significant, particularly as the prospect of recovery of damages from the protesters is frankly nil. Any contingency planning that can be done to preserve your operations or to minimize disruption could have significant benefits for the company involved. The 10th point is that by having an awareness of potential health and safety risks, you can also arrange for prior training for your employees at your sites to ensure that they know how to act and respond if a protest was to take place. For example, individual protesters can be extremely provocative and hostile towards your staff or contractors. A lorry driver who is feeling under pressure to deliver to a site timeously could, when faced with a protester trying to get on top of their lorry, lose it for a moment and drive his lorry into the protester. Clearly, they should not do that, and the right course of action is to stop the lorry, not only from a basic human perspective, but also for PR reasons. Accordingly, internal training can be very important. 11th point is that an action for interdict will normally also include a request for the court to grant an interim interdict. To avoid causing confusion, Steve and I have referred to interdict generically through our talk, but for the avoidance of doubt, an interim interdict is a provisional remedy which is granted to preserve the status quo or to prevent temporary or imminent wrong pending the court's final decision. That is to be contrasted with a final or permanent interdict, which is granted at the end of a case, but only once the court has heard all of the evidence. In practice, most protester cases do not get far beyond the interim interdict hearing, because once it is granted, the protest usually ends and there's nothing else to litigate, other than in those cases where contempt proceedings are actually instituted. An interim interdict will only be granted if the energy company can prove it has title to sue, a good arguable case on paper, and that the balance of convenience favours the interim interdict being granted. In other words, the weighing up of the respective prejudices to the energy company and protest group in granting the interim interdict on the one hand and refusing it on the other. The detailed facts are relevant to all of these three issues. Finally, even if there are good grounds for interim interdict to be granted, the order must be expressed in precise terms so that the party you are seeking interdict against is left in no doubt as to what they are restricted from doing as a result of the interdict. This is because breach of an interdict is a wrongful act, and willful breach is a contempt of court. The person subject to it is therefore entitled to know with precision what he must not do, and the terms of the interim interdict must be no wider than is necessary to curb the unlawful acts complained of. In addition, it must be clear who the interim interdict is sought against. The problem with protests is that you are unlikely to know the names of all of the protesters who plan to carry out a protest, or which particular group or company of a particular entity, such as Greenpeace or Extinction Rebellion, is carrying out the protest. As set out earlier, once a protest takes place, it's sometimes possible to identify the protesters either by reference to the individual's names or by reference to the location they are occupying. However, it's more difficult to do so where you are seeking an interdict to prevent an anticipated protest. In any event, such a definition must not be too wide to include people who have no intention of carrying out the protest at all. So in conclusion, it can be seen that protests over the years have caused a number of problems, risks and issues for the organisations that they target. Unfortunately, it is impossible to prepare fully for a protest taking place at your site. However, there are steps you can take to ensure that you're in the best possible position to take action as quickly as possible to reduce the impact on your organisation. Steve and I will be happy to answer any questions now, or if you prefer, we'd both be happy to pick up with you after the seminar. Thanks.
Brilliant. Thanks, Steve and Jamie. That was great. Really interesting and very topical for our audience. As Laura mentioned earlier, we're going to now move on to the Q&A part of the session. I'm conscious of the time, so we might only have time to field a couple of questions which have come in privately. So the first question I think is for you, Jamie Kerr. Do you see any oil and gas specific changes in the pipeline?
I like your pipeline pun now.
Thank you.
So yes and no. I don't see anything drastic changing in terms of the offshore rules, because I did pick this up with the Immigration Minister last year when they were looking at the new system, and I think they were kind of blindsided as to the offshore rules. The offshore wind concession is a good example of something that can quickly appear and then quickly disappear. Again, that's for offshore wind farms. So some of what I would say in terms of sector-specific changes is there's nothing sector-specific in pipeline as such, but if there are things that do work or don't work, you should be lobbying to flag that to the Home Office, and they will make changes as the offshore wind farm concession shows, but those concessions can be short-lived. But engagement is probably key to ensure that any changes that do come, like the intercompany transfer changes across the board, are still suiting your business needs.
Brilliant. Okay, thank you. We'll just squeeze in one more. I think it's for Stephen and Jamie Wilson. Guys, how long would it take to obtain the court orders which you have discussed?